In this video, we're going to talk about the duty for someone to disclose certain information at the beginning of your family law case. Hi, I'm Sean Palmer with the Palmer Law Firm, and there has been a major change in the discovery rules in the state of Texas on cases that involve family law matters. And the discovery is the process of finding out information. Previously, in the old rules, prior to January 1st, 2021, the party who was filing a lawsuit would file the lawsuit and serve, and then we might enter into a discovery phase after the initial part of the case has gone on. And discovery means basically trying to get documentation and information about the case that will help you to put the case together and present it to the court. And prior to January 1st of this year, 2021, the lawyer had the ability to decide whether or not to do formal discovery, and that means whether or not to request documents or to answer written questions on the record. But that has been changed quite a bit by the new rules under the Texas Rules of Civil Procedure, particularly under 190, 192, 193, 194, 195. Those have taken effect now, and so the old discovery rules are not there, and your attorney must gather information at the beginning of the case, and there's no discretion on that. So under the new rules, you're going to have to produce information for your attorney, and your attorney must send that information to the other side within 30 days of when the answer for the pleading was due. So parties are now required to produce answers to certain questions early in the case. They're also required to produce any documentation that they want to put forward to try to present to the court as their own evidence. And those documents, which normally we gather up later in the case, is now required at the very beginning of the case. So if you haven't filed for a divorce or child support or child custody case, early on you're going to want to gather documentation together because you're going to need to produce it for your attorney, and your attorney's going to ask for it. So what are the things that you have to disclose, what we call disclose under the new rules? Well, the first thing you need to do is we need to disclose the correct names of the parties to the lawsuit. We have to produce the name, address, and telephone number of any other potential parties, and in most cases in family law, that'll just be the mom and dad or the husband and the wife. Usually there's not another third party that would come in. You also have to make a list of the legal theories and, in general, the factual bases for those legal theories about what you're trying to achieve. So your lawyer definitely was going to be needed in this part of it, because your lawyer is going to have to tell you what the legal theories are of your case, but you're going to have to produce information to your lawyer about facts that would support what you're seeking. So, for example, if you are trying to make a claim of adultery and you have some sort of videos maybe or something relating to that, and you want to use those in court, you have to produce those at the very beginning of the case. So that's required. And you're going to need a copy of any other documentations like account statements or basically anything that you want to prove in terms of property, titles, things of that nature. You're going to have those ready to go right at the beginning of the case. There's some other things that aren't as common but are required, like indemnity and insurance agreements, settlement agreements you might have had, any statements from witnesses they might have written down, And if you're alleging physical or mental abuse, then you're going to have to, and you want to show anything, you have to produce all the medical records and bills that are related to those injuries. And the name and address of any person who might be designated, as I say, as a third party. You have to produce all that information. And so we call those kinds of things, we call those initial disclosures. And those are due right away, so you should have that information ready to go when you go to your attorney for the first time or very soon after hiring him. Now, in a divorce, there are other documents that you're going to have to produce on this initial disclosure as well. And those documents are all documents that have anything to do with your real estate, say title documents, loan documents, deeds. You're going to have to produce all documents pertaining to any pensions, retirement, profit sharing, or any kind of employee benefit plan. If you got a 401k, if you're getting a pension, I don't know, many people aren't getting pensions nowadays, but anything like that nature that is community, potentially community property, you have to produce the documents about that right at the beginning. You have to produce all documents of that show any life insurance, health insurance. Those have to be produced. You have to produce the most recent statement of any account at a financial institution. So that's your checking and savings account. For your banks, it includes savings and loans. And it doesn't matter whether it's solely in your name or not. Remember, the community property rule is that anything you accumulated from the time you're married until the time you're divorced is community property and subject to division in the divorce. And you have to prove why there's an exception to that rule. Say you inherited something or something was given to you as a gift. Those are exceptions. So pretty much anything that you have, whether it's in both your names, one of your names, or otherwise, it has to be produced early on in this initial disclosure. Then if you have child support or a spousal matter of getting maintenance for on a temporary basis or on a long-term basis, if any calculation of somebody's income is required, such as calculating for child support or determining whether spousal maintenance is going to happen, then you must also produce in that initial disclosure all of the policies, statements, and summaries for any medical and health insurance coverage that you have. You have to produce your income tax returns for the last 2 years. And if you didn't file a tax return, then you have to do last 2 years of W-2s, 1099s, and Schedule K-1s. And then you also have to produce the parties' 2 most recent pay stubs. Now those last things, the child support, income, financial information, that is pretty much the rule for the family courts in most of the counties in Texas, particularly in the counties I practice in Galveston and Harris and Chambers. You had to do that anyway. But under the new rules, you have to do it in all cases in all counties in the state of Texas. So, again, in summation, the new discovery rules require us to produce documents and to make statements very early on in the case. We call these collectively disclosures. And they must be done. The attorney doesn't have the option of cutting that out of the case or seeing if they can save you some money by not going through these. They must be produced. And the consequence of not producing these disclosures can be very, very bad. Sanctions are when you don't follow the rules and the judge slaps you down for not following the rules. And sanctions can include, in order to compel you to do the things you should have done in the first place, but also maybe even attorney fees for the other side to, if they had to enforce the rules in front of the court may punish you by making you pay the other side's attorney fees. And there may be other sanctions, up to and including dismissing your case if you're the one filing for it. So you don't want to run afoul of those rules. This is a kind of a complicated process now. It is the law. It has been passed, and some people aren't, happy with it. But it doesn't matter. Those are the rules, and we have to follow them. So try to get that information together early on in the case, and help your attorney out with it. And if you have any questions about this topic, please give us a comment below, and we'll try to answer that and get the answer to you. So I've gone through this, and I hopefully it's understandable. And thank you for your time. So I'm Sean Palmer with the Palmer Law Firm, where we can't mend your heart, but we can protect your rights. So let me know if there's anything we can do for you. Thank you.